This video, presented by the Equal Rights Center, will discuss fair housing best practices that all landlords in Washington, D.C. should know. Let's start with the federal law. The Fair Housing Act provides for protections from discrimination on the basis of race, color, national origin, religion, sex, disability, and family status. These protected traits apply all across the country. In Washington, D.C., it is illegal to refuse to rent or sell to someone based on 13 additional protected traits. These include personal appearance, place of residence or business, political affiliation, sexual orientation, gender identity or expression, age, family responsibility, marital status, matriculation or student status, status as a victim of intrafamily offense or domestic violence, homeless status, sealed eviction records, and of course, source of income. What are legal sources of income? Common examples include housing choice and rapid rehousing vouchers, veterans and disability benefits, rental subsidies, and emergency assistance. Even a housing provider who is willing to rent to a voucher holder may make a mistake when determining when a prospect is qualified to rent a particular unit. Housing providers can still use standard qualification metrics to decide who is qualified to rent a unit, like looking at someone's credit, rental, or criminal background. However, landlords should ensure that the standards they are using are applied equally to all prospects. So, what are common mistakes that housing providers may make that could be considered illegal discrimination? Landlords should never say or advertise no Section 8 or no vouchers allowed. Instead, you should use affirmative language and advertise vouchers accepted. In 2020, Washington, D.C. passed a law that requires all district landlords to state that they are willing to rent to voucher holders in advertisements. Landlords cannot discriminate against tenants based on having a housing voucher. For example, a landlord who denies an application because a prospect's only source of income is their voucher could be illegal discrimination. Landlords should not treat voucher holders differently. And remember, there is no pre-approval or pre-qualification process by the D.C. Housing Authority. Units are approved by the Housing Authority after a landlord accepts a voucher holder's application. According to the Eviction Record Sealing Authority and Fairness in Renting Amendment Act of 2022, landlords should not deny people with vouchers due to a low credit score or not having a credit score. Landlords should not consider any negative credit information that occurred prior to a tenant getting a voucher. You should not apply a minimum income requirement to any voucher holders. And if a tenant's voucher covers the full amount of rent, meaning the tenant portion is zero, it is also likely illegal for a landlord to reject an applicant for any reason related to credit. To stay in compliance with the Fair Housing Act and local laws that protect voucher holders, families with children, and people with disabilities and assistance animals, check out our landlord trainings and online webinars, or contact us using the information on the screen. Thank you.